Good afternoon. Please be seated. We have one case for argument this morning, Emmer and Petition regarding the 2010 gubernatorial election. Ms. Bradfold, you reserve 5 minutes for rebuttal. You may proceed when you're ready.
May it please the court, Diane Bradfold on behalf of the petitioner, Tom Emmer. In the brief time I have to speak to the court today, I'd like to focus on the core issue presented by the Secretary of State's brief. Does the statute control the number of lawfully cast ballots, or does the rule cited by the Secretary of State? Our position is clear. The voters' signatures, as provided by statute, not the voter receipts, as provided by the rule, are the cornerstone for determining the number of lawfully cast ballots. Now, the statutes recognize 3 types of documents in addition to the ballots cast. First, the voter certificates, second, the voter rosters, and third, the voter receipts.
As I understand the process used today, that voters' receipts don't exist, and what's the other one? The election register doesn't exist. Is that correct?
The voter certificates are no longer used, Your Honor. The voter receipts are used.
Well, the statute provides for voter receipts and election register, or am I missing something?
No, I think the statute you're referring to is 206C20. The marshal has distributed to the members of the court a package of the copies of the relevant statute. So just to make sure we're on the same page, Justice Page, I think.
204C20?
Yes, and so that'd be tab B. Is that right? The determination of the proper number of ballots to be counted?
Well, counsel, let me just follow up with what Justice Page, I think, is asking. And I think that the trouble I'm having with your argument is that in order to get where you want us to go, it seems to me that what you're essentially saying is that the phrases voter certificate and election register in 240C20 are ambiguous. Your opponents, I think, argue that the phrases are obsolete, and they want to, they argue that we should replace those phrases with polling place, roster, and voter certificate, which are the terms that are now in 240C10. And they also turn us to the Minnesota rule, which I presume went through the rulemaking procedure, right? So my question is, are you contending that voter certificate and election register are terms that are clear in their face in 240C20 or not?
240C20 is clear in light of the legislative history, viewing that statute in context with 204C10. And that's the statute that I think this court needs to attend to in terms of the modern terminology. Now,
well, isn't it true that if we go back to 1978, that election register was something that the election judges did, and that we do not, in other words, someone came in, they wanted to vote, they went to an election judge, the judge asked them certain information, they were put under oath, the election judge then put their name on the election certificate. And we don't have that process today, right?
no, that's correct, Your Honor, but signatures by the voter are essential for the voter to exercise a voter's right to
Well,
vote.
they did not have that procedure for election registers, however, did they?
For election registers?
Correct. In 1978, there was no requirement that a voter had to sign an election register. That was something that was filled out by the election judge, right?
The voter certificate was signed, Your
I'm not
Honor.
talking about that. I'm talking about an election register. Am I correct about that?
I'm not sure, Your Honor.
You're not sure.
No, I'm not sure.
Well, then...
I think what is important, though, is that the signature was placed on the voter's certificate.
Well,
And the
if-
voter's certificate is something that has been amended by the legislature in 204C10, the tab A in the materials provided, in which that became the polling roster, Your Honor, and that is exactly what should be counted today, the signatures of the voters on the voting roster.
Well, it seems to me that, at least as I read the affidavit of Mr. Mansky, he states that the term polling place roster can be substituted for the term election register, and that the term voter receipt can be substituted for the term voter certificate. And that seems plausible to me, and I'm just wondering why that is not a reasonable interpretation here.
Well, it's not consistent with the legislative history, Your Honor. The voter's receipt, in fact, was something that was destroyed routinely until 1999
Well, we don't
the
even
statute.
get to legislative history or purpose unless we conclude that the statute's ambiguous, and you just said the statute was not ambiguous.
That's correct. The statute's not ambiguous. There's no need to insert voter's certificate when, in fact, it's the signed polling roster that is maintained, and it is the expression of the voter's right to vote.
Counsel, let me ask you this. The 204C.20 sub 1 provides for signed voter certificates which no longer exist and an election register which no longer exists. So if the statute provides for things that no longer exist, how could we say that the statute is not ambiguous?
I think all statutes have to be read in context, Your Honor, and this statute doesn't stand alone. All parties, the petitioner and the respondents, agree that to construe point 20, we have to look at point 10. And the session laws underlying point 10 make it quite clear that the legislature has substituted the signed polling roster for the signed voter's certificate. And in fact, the election register was done away with, but the only substitution that remains today is the signed polling roster. Those session laws are included in the materials provided for the court.
So your argument is that we should construe signed voter certificate to mean polling roster.
Signed voter certificate from point 20, yes, that's correct, Your Honor.
Well, you only get a voter receipt if you've signed the polling roster, according to the statute anyway. And so if we just follow your argument through, why isn't voter receipt the equivalent of signed voter certificate?
The legislature has never permitted voter receipts to substitute for the signed voter certificate. They have instead substituted the signed voter certificate for the signed polling roster for the signed voter certificate. It's the signature that's crucial, Your Honor, and there is no signature on the voter receipt.
Counsel, let me just take that one step further. So the point is to count the number of people who have signed as voting, correct?
That's correct.
Okay. So let's just change this a little bit. So when you sign a vote, I give you the chit, okay?
Correct.
The voter receipt.
The voter receipt.
You give the voter receipt in exchange for a ballot. And you keep all the receipts. At the end of the night, they should add up to how many people signed, right?
Correct, theoretically.
Okay, so what if, instead of handing the chit, what if I'm the election judge and I have a pad of paper next to me, and I'm the one who's getting people to sign, and you sign the roster, and I put a little hatch mark on a legal pad sitting next to me. And every time someone signs the roster, I put another hatch mark on the legal pad next to me. And at the end of the night, I've got a bunch of hatch marks on my legal pad. And those are really easy to count, and they add up to 4,230. And that's the number I verify as an election official of people who signed the roster and were given ballots. Would that be an illegitimate counting of people who registered to vote who voted that day?
It certainly would be an ad hoc estimate. It would not be consistent with the statute. The statute for very good,
The statute doesn't say at the end of the day you have to go back and add up how many people signed the roster.
Yes, in fact, it does say that.
Well, then, when it does, then what do you say? You have to do it, you can't do it as you go?
No, I'm not suggesting that you couldn't have an informal tally along the way. I don't think the statute prohibits that. But when the final summary statements are prepared, it's essential that the voters' signatures from the polling roster are what is counted. It's very important to start with the right number, to begin at the right reference point, or the end result, the report that is
Well,
then
the right
processed
reference point is at the
onward will be
beginning
wrong.
of the day, but there's 0.
No, well, that certainly would be true at 7 a.m. when the polls open. But by the end of the day, how is the blank going to be filled in on the summary statement to determine the number of voters that voted? The legislature could have chosen many different systems. The legislature chose one very specific one, to
Counsel,
count the signatures on the voting roster.
What's the practical effect of what you're asking here?
By that, if Your Honor means a practical effect in this particular election, of course, we don't know what that is.
Well, I'm having trouble only in that you only get a receipt if you've signed the register. So it strikes me that the practical effect is you end up with the same number either way.
Well, we know that's not true in many races. In fact, all of the affidavits submitted by the respondents in this case indicate that there are situations where excess votes occur, where there are more votes cast than there were voters. And so in a myriad of different ways, there are excess ballots. And because that is true, it is important to declare the starting point for determining the number of voters. At the end of the day, each precinct is supposed to balance. The number of votes should be the same, votes cast should be the same as the number of voters. The only way to determine that is to count the signature on the voting register.
Counsel, I've got a different question, and that is, it relates to 204 C10 subdivision C. In there, it tells us that you get a voter's receipt, which serves as, quote, proof of the voter's right to vote, close quote. And my question for you is, in light of that language, aren't we really arguing about form over substance here? At the end of the day, isn't that voter's receipt simply proof of the underlying signature? And even if you're right that the signature is the key, given the language in 204 C10C, doesn't that allow for the counting of those voter receipts?
We are not arguing about form over substance. We are in fact arguing about how the correct number of lawfully cast ballots will be determined. There could be something of no greater significance than that single question, particularly here where we are going to enter an automatic recount. So in light of that, in light of the acknowledgement by all of the respondents that in fact they don't follow the statute, that the counties instead follow the rule issued by the Secretary of State, it's vital for this court to determine how the correct number of voters will be counted.
You're overstating it a little bit if you say that respondents acknowledge they don't follow the statute.
They follow the rule.
Correct.
You're on. The rule issued by the Secretary.
I think it's
Excuse
a
me,
misstatement to say that county officials, election officials are admitting they don't follow the statute.
The county or election officials have admitted that their practices are consistent with the rule issued by the Secretary of State.
Why isn't that rule, why doesn't that resolve the issue here? Why is that, is it your view that that rule was improperly promulgated, that the rulemaking procedure was flawed in some way? Or are you simply saying that the rule is inconsistent with the statute and therefore we should disregard it?
Our primary argument is that the rule is inconsistent with the statute. Obviously, the Secretary has the authority to promulgate rules that are consistent with the statute when it has been authorized to do so. The supplemental brief that we provided with the court and are hoping that you will accept does include an analysis of the authority of the Secretary as well. But importantly, the rule itself is inconsistent with the statute, and that's exactly what's laid out in the session laws.
If we conclude that the rule is consistent with the statute, is there any way that you can prevail?
It's difficult for me to entertain that thought, quite honestly, Your Honor, because I don't see how the rule can be viewed as consistent with the statute. Because,
Can you humor us?
pardon me?
Can you humor us?
I'd be happy to humor
you.
you. If you're seeking that concession, and if the court can so broadly construe the statute as to authorize the rule promulgated by the Secretary, that would be a different story. Our petition is premised on the statutes provided by the legislature for how voters' votes will be counted, how the number of voters will be determined, and how the number of lawfully cast ballots will be counted. It is
Counsel, your time has expired. You have 5 minutes for rebuttal.
Thank you, Your Honor.
Mr. Gilbert, you have 10 minutes.
May it please the Court, my name is Alan Gilbert, and I represent the Secretary of State in this matter. I think the Court has really drilled down into what the issues are on this particular matter, and the way I see it, petitioner just can't have it both ways. Petitioner is saying that the statute is clear on its face when it references obsolete terms that haven't been in existence for 20 years, and our election system has...
Before we get to those
Yes.
issues, and those are significant, and at the risk of dragging us off on an issue that may not be directly before us today, I do have to raise a question about something that caused me to sit up and take notice, and that is there seems to be some indication in the pleadings filed by your side of the case that in acknowledged circumstances where there are overages, administrative officials have made the decision that those are de minimis and they're not going to take ballots out as the statute seems to require. That seems to me in direct violation of the statutory language. And I realize that question may not be directly before us on this interpretive question, but shouldn't that be a matter of concern?
Your Honor, I know what you're referring to, and I think the situation that you address is one where there were some de minimis ballots involved in that, but there was a judgment made that those people who actually casted those ballots did do so legally and validly, and rather than disenfranchise those voters, they decided that those ballots should be counted.
Well, of course, by doing so, they have essentially diluted, if not disenfranchised, the votes of people whose votes were properly cast. I mean, if we have an overreach here, obviously there's a problem, it seems to me. And
well, except the overage is de minimis. In one county, I think it was 5 votes, and the two most populous counties are talking less than...
And maybe at the end of the day, it's a harmless error kind of situation, but from this standpoint, where we are today, it strikes me that having election officials taking it upon themselves to say that something is de minimis and not following the statute is a matter of some concern.
Well, Your Honor, my word is de minimis, and it is de minimis in terms of number. But my understanding is that the county officials, exercising their discretion, made a judgment that those ballots were validly casted, and they do have the authority to do that.
Well, if it were 2 or 3 per precinct, it wouldn't be de minimis.
Well, it wasn't 2 or 3 per precinct, though. The filings that you're referring to are in the 2 most populous counties in the state of Minnesota, Hennepin and Ramsey County. And I think between the 2 of them, we're talking less than 30 ballots for the entirety of those 2 counties.
Are you willing to concede that that's error on the part of those election officials?
Your Honor, I'm not, because as I understand it, those election officials determined, as they have discretion to do, that those ballots were validly cast. And I cannot give you chapter and verse why they made that judgment, but they did make that judgment. And as a result, I'm not in a position to disregard it.
Counsel, as I look at subdivision 2 of 204C20, I have the same concern as expressed earlier. I don't see anything in the statute that gives the election official the authority to say, well, this is de minimis, therefore I'm going to disregard it. It seems to me that if there is a process and the process is followed, then, and there still is an excess, that one election judge, without looking, shall withdraw from a box a number of ballots equal to the excess. That seems very clear to me, and it seems very clear that that was not followed here. And I don't know how, it seems difficult that we as a court should turn a blind eye to that.
Your Honor, all I'm saying, first of all, I'm not saying because it was de minimis, they made that determination. My understanding, again, based on the filings that they have made with the court, is that they made a judgment those were validly cast ballots. And they have certain discretion to make that determination. And there are some implications to it in terms of disenfranchising voters, and they made the judgment that in light of that, that they would count those ballots. My point about it being de minimis is that it really doesn't affect, in the grand scheme of things, the outcome of the election. And this court is here to do justice under the circumstances. And what we have is a canvassing event. The canvassing board is meeting tomorrow. And what the canvassing board and the Secretary of State would like is to be able to move ahead with their responsibilities to perform the canvass and, if necessary, the recount that may be required by statute.
Can you help me with the reference to election register, and the question that was asked by Justice Dietzen earlier, which is whether or not whether or not the election register was signed by the voters? I have this understanding, and it may be wrong, that in fact the election register was not signed by the voters.
It is not.
And is there some authority for that somewhere?
Your Honor, I don't have it at my fingertips. I believe there's even a statutory provision that acknowledges that. But the election register is not signed. And that's evidenced somewhat by a subsequent reference, for example, in the rule that refers to signatures on the election roster. So that, at least at that point in time, there was a determination that there were actually signatures. People were actually signing the election roster.
Counsel, let me ask you this. The rulemaking authority seems to be focused on developing a registration system and not on counting votes after an election. And so where does the authority?
Well, first of all, Your Honor, the rule that was enacted in 1982 was enacted because of a change in a statutory provision dealing with the new election registration system. So that's the connection between the rule and that particular authority. But
that doesn't answer the question about whether in the first instance the Secretary of State's office had the authority to write the rule.
Well, it does have authority, Your Honor, under the election registration statute to adopt rules to implement the law. Now, I also want to point out.
But how does this, which is Justice Page's question, this has to do with counting afterwards, not implementing a system, but counting afterwards?
Well, but counting afterwards because of the registration system. Because what happened with the registration system is that people got a voter's receipt. And what happened as a result of that is that the voting certificate no longer existed. So to deal with that glitch in the law, they had to provide for what the alternatives are to tabulate at the end of the evening on election night. I also want to point out, Your Honor, that this rule has been in effect, as you are well aware, almost 30 years. And the rule is deemed to have the full force and effect of the law. It's deemed to be as valid as a statute. And there is a mechanism in Minnesota law.
Presumably until challenged and found to be inconsistent with.
And that's my point. There's a mechanism in statute as to how you challenge a rule. And that's under Minnesota statute 14.44 and 14.45. It's not the sole mechanism by which you might challenge a rule, but it's a procedure where you can actually go to the Minnesota Court of Appeals. They have original jurisdiction over the issue. And someone can claim that a statute is invalid for whatever reason, and the Court of Appeals has that authority. Now, in this case, I think that authority is particularly appropriate because the petitioner in this particular case was well aware of what Minnesota election law provided for.
Counsel, is the Secretary of State's office making any, well, let me back up one step. We have jurisprudence on rulemaking and whether an administrative agency has authority to promulgate rules.
Correct.
Is the Secretary of State's office making any argument that that jurisprudence does not apply to it because the Secretary of State is a, shall we say, a constitutional office and not an administrative agency?
No, Your Honor.
Okay.
No argument to that effect. But one thing I want to point out about the source of the authority for the rule is that it's not entirely clear what all of the bases might be for that authority. One aspect of 1444, if there was a proper challenge before the Court of Appeals, is that the record from the from the rulemaking proceeding has to be part of the challenge. And before this court, it would have to be part of the challenge. We we haven't even found the rulemaking record that goes back to 1982, but it's the burden of the petitioner to put that record before you. And that record would reflect what the authority is. And I would point out that the administrative law judge, who was responsible for overseeing that rulemaking proceeding, determined that not only did the agency have the authority to adopt the rule, but the rule was reasonable under the circumstances.
You make the argument with respect to latches, and I note that counsel for candidate Dayton also makes that argument. But in response, we were told that the voter guide, the manual provided by the Secretary of State, provides for counting signatures on the roster, and that that's the process that should have been followed here. Do you agree or disagree with that statement?
Well, Your Honor, very specifically with that point that you make, yes. But the Secretary of State, as evidenced by the affidavit of Gary Poser, also sent out information separate from that, actually referencing the rule and referencing the fact that you alternatively can count voter receipts. And that same information was provided by Secretary Kiffmeyer back in 2006. It was provided by Secretary Ritchie in 2008 and again in 2010. And frankly, because of the expedited proceeding here, we haven't been able to get more information as to prior years, but we suspect as to prior years, it might even go back to 1982, that was the custom and practice of the Secretaries of State to provide that kind of information to the local election officials.
Thank you, counsel. Your time has expired. Mr.
Thank you
Elias.
very much.
May it please the court, my name is Mark Elias and I'm here on behalf of Mark Dayton. It seems to me that the bottom line issue that the court has focused in on appropriately is how do we accurately count votes? And I think that Justice Meyer, your point about whether you kept a tally as you went along, whether you count the receipts, whether you count the signatures, the goal of the statute, the only sensible purpose of the statute is to ensure that the votes are counted accurately.
Would you agree that the gold standard would be a signature from a voter indicating an intent to vote?
No, Your Honor. I believe that the reason, and this is true in other jurisdictions in the country, why they prefer to count the receipts rather than the signatures, it is much easier to make an error. I mean, think about it. When you hold up a piece of paper, if I said, count how many lines are on this page, it is much harder than if I said, count how many pieces of paper this are, where you can say 1, 2, 3. It actually, I suspect, though I don't know, the gold standard is exactly what the Secretary of State has recommended, or what is embodied in the rule.
Well, isn't that argument undermined a little bit, though, by the fact that the legislation used to require used to contemplate the destruction of voter receipts?
I think, Chief Justice, I think it's two separate questions. One is, what is the gold standard, and what did the prior legislation? It may be that the state of Minnesota learned from its experience and actually moved from a less good standard to a better standard. But I don't think there's any question that the current standard is an accurate way of counting the votes, which is what, after all, presumably everyone on all sides of this are interested in. I want to address briefly the question of waiver that came up. One of the principles of election administration law generally, and you find this in disparate cases, and I want to be clear, I'm not saying that those cases control this instance, but you see it in disparate cases as far-flung as Sheehan versus Franken, Bell versus Ganaway, Bush versus Gore, Roe versus Alabama, and of course Clark versus Plenty. All of them stand for the same proposition, which is that once the ballots are opened, and once you know the vote total, courts should be skeptical about procedural challenges that could have been brought earlier. That the time to challenge the voting process is before the election, when the veil of ignorance still stands as to whether this process or that process will benefit one candidate or another. And I would urge this court to look at the fact that this was a promulgated regulation. This regulation's been on the book for a long time. There have been dozens or hundreds of elections conducted in the state of Minnesota using this standard.
But then what are we to do with the election guide that the Secretary of State's office issued, which says, count the signatures on the roster?
I
mean, why is it wrong to say that, as petitioners say, or as petitioner says, I thought that the local election officials were going to do what the Secretary of State's office told them to do in the election guide, which is count the signatures on the roster. And I relied on that, and that's why I didn't bring this lawsuit before.
Well, I think they also could have relied upon, and I want to be clear, given the quick nature with which this lawsuit has proceeded, I can't attest to every piece of paper that went out and what other additional materials may have been distributed, but I think it's fair to say that Representative Emmer was a statewide candidate for the highest constitutional office in the state. He had lawyers available, and these regulations, despite the fact that they don't appear in the handy guide that have been handed out, this rule appears on the books. It's published. It's not secret. If they wanted to know how it was that election officials would go about counting, they could read the regulation, which uses the up-to-date terminology.
Is it your position that counting the voter receipts complies with the Secretary of State's guide to count the signatures on the roster?
I believe it does. It does, Your Honor. It complies with the rule that is in place, and that is what you can ask. All you can ask an election official to do is to comply with the law as it's written and the regulations that have been promulgated under that law.
Is it your position that Section 204C.20 is ambiguous or unambiguous?
I think that it is out of date, and I think that regulations are used to fill in gaps where a regulation is either ambiguous because it's just some statutes come ambiguous, and others become ambiguous because as time moves along and technology in voting surpasses what was originally the case when the statutes were passed, it essentially has the functional equivalent of becoming ambiguous.
So that's a yes? Is that a yes or a no?
I think it's out. I think that the terminology in that provision is out of date.
Well, and therefore ambiguous. In other words, can this court literally enforce the terms voter certificate and election register when election register no longer exists?
Which, Your Honor, is the reason why agencies promulgate regulations, to fill in where there is a statute that is either ambiguous or is out of date. It is the job of the Secretary of State who's administering these elections to ensure that those gaps are filled in and that election officials and the public and candidates know how the elections will proceed.
We do, of course, have the obligation to construe the statutes as a whole, and why wouldn't we construe voter certificate as used in point 20 to mean polling place roster as discussed in point 10, because both refer to the signature?
I think in some respects the signature issue is a bit of a red herring. I mean, the fact is that the purpose of having signatures serves an anti-fraud purpose. It helps you ensure that you have the voter sign something so that you can compare the signature to another signature, or that you can later identify who the voter was. The purpose of the provisions we're talking about now are not about fraud, they're about counting. They're about what is the most accurate way, the most surefire way that we count up the ballots to make sure that pile 1 and pile 2, or one list and another list reconcile. And in that instance, the fact that there would be a signature or there wouldn't be a signature, you're not going to count a pile of paper any better because it has a signature, and you're not going to count it any worse because it doesn't have a signature. So I think in some respects, the focus on whether there is a signature on the slip of paper or not really is irrelevant to the question at hand today, which is what is the most accurate way to reconcile for an election official in a polling place to conduct a reconciliation. I wanted to just end with a brief word about the question of overage. I'm not sure that it is before this court. I'm not sure the issue is properly or currently before this court, but I would just be remiss if I did not say something about it. The fact is that there are times where the two numbers won't match, where the election official knows why it is. And it's not because there were unlawfully cast ballots. In fact, it may be precisely because there were lawfully cast ballots. A disabled person may come in to vote who's unable to sign a register. But they know. The election worker knows that that's what happened. and that's the reason why the signatures don't match. It may be, and I think that this was one of the affidavits, that they see that there are two ballots that were back to back, and they voted the front of one side and the back of the other side. But it was that voter cast one vote. But you wouldn't want to throw that person, half that person's ballot out because the election official gave them two ballots that were stuck together. In fact,
But counsel, it seems to me that your policy arguments run headlong into the statute. In subdivision 2, if there is an excess after a certain deliberative process is followed, then the excess has to be removed, right?
right, Your Honor, but the question...
My problem is that didn't occur here.
The question, well, first of all, we don't know whether it occurred or not, but I take Your Honor's point. And the question, though, is whether there is an excess. And I point this court to footnote 11 in Coleman v. Ritchie, in which the court was having a dispute over whether or not subdivision 2 of section 204C2 was having a dispute, by the way, with the dissent, whether subdivision 204C20 simply required a, quote, rough arithmetic check. And what this court wrote was that that section, quote, requires election judges to randomly remove excess ballots if a discrepancy cannot be explained. Cannot be explained. This court understood in that opinion that it is not, that a ballot does not become excess if an election judge, if the election worker says, I know why this didn't match, I know why it didn't match. At that point, there is not an excess ballot. And again, I'm not sure this issue is properly before the court, but I didn't want there to be, I didn't want silence coming from this side of the courtroom to suggest that there is agreement. And I apologize, I realize my time is up, so I'll...
Thank you, counsel. Your time has expired. Ms. Bradfold, you have 5 minutes for rebuttal.
I'd like to begin with the question of whether voter receipts should be used instead of signatures on the polling roster. The question raised by, in fact, one of the affiants, county affiants, was whether that's more accurate. And the discussion with Mr. Elias with respect to whether that is a gold standard, perhaps, the voter's receipt as opposed to the signature on the voting roster. Fraud, of course, does require the signature. Concerns about fraud in the voting process requires the signature by the voter. And that's the history of that. The lawfully cast ballot requires a signature by the voter. And that's an issue that this court and other courts encountered in the consideration of absentee ballots, and those in which the signature was not present, the absentee ballot was not allowed. State law requires the signature before the vote is cast, before the vote may be counted. It may be more convenient to use other methods. There may be different methods available, such as the one suggested by Mr. Elias, where the election judge would look at explanations for why there are excess ballots or why there aren't excess ballots.
Counsel,
but the law can be that way and must be followed nonetheless.
Counsel,
Yes, Your Honor.
could you, Justice G. Barry Anderson asked about 204C10 subdivision C. Could you explain to me again why that doesn't answer this question, that the receipt is proof of the voter's right to vote?
The receipt is proof of the voter's right to vote, and that's what allows the judge to hand over the ballot to the voter. It is not proof of the proper number of voters to be counted or the ballots to be counted. That's what we get from point 2.0, Your Honor. So point 1 has to be read in context with point 2. There's no way to separate one from the other, and that's not simply because the terms in point 2 are no longer used today. It's because the two statutes are part of the same electoral process.
Well, they may be part of the same electoral process, but it seems to me that at some level, just applying our normal rules of statutory construction, that given the, I'll use the word obsolete language in 204C.20, it's not clear to me that the statute is even applicable.
Point 2 is not applicable. I don't know how that could be said, Your Honor, and that is, in fact, how the proper number of ballots to be counted is determined.
When certificates don't exist?
The certificates, however, have been supplanted by the signature on the polling roster. That's what point 1 provides. And as I said, the legislature is quite clear in its intent. The words it struck were voter's certificate and put in its place the signature on the polling roster. So there's no doubt about how the legislature expressed its intention that the signature would be carried over the roster.
They didn't put it in point 2.0.
That's correct, Your Honor, but they also did not substitute voter's receipt as what would be counted in point 2.
So are we left with nothing?
No, we're not left with nothing, because there are signatures on the polling roster, and there's no doubt that those can be counted and should be counted. It's even included in the voter's guide promulgated by the Secretary of State, as has been noted by the questions of the members of the court. One issue that's certainly got to be of concern to this court's public confidence: how will the public view this case? How should Mr. Emmer's petition be viewed in light of his situation as a challenger in this case?
Counsel, can I just ask you a question about the Secretary of State's authority to promulgate the election guide? I mean, your position is the Secretary of State didn't have authority to promulgate the rule. What's the Secretary of State's authority to promulgate the election guide?
Well, I haven't researched that particular question. I think it was provided as training materials, and if you'll note, that page in which they say that, in fact, the signatures on the polling roster should be counted cites to this statute, 204C.20. So the Secretary of State is purporting to relate in training materials to election judges what should be done when the poll is closed on election night. On that night, the signatures should be counted on the polling roster. I assume the Secretary of State had authority to do that in light of its need to train. The integrity of the voting process, and in particular, the counting of votes, requires that votes not be diluted, that the process for determining the proper number of voters and the proper number of votes cast be those that are lawfully cast by voters who have in fact signed into the polling roster. No extra impermissible ballots should be allowed, and the petition should be granted. Thank you, Your Honor.
Thank you, counsel. Thanks to all counsel, those we heard from today and those we heard from in writing. This matter is submitted. We'll issue an opinion. We're adjourned.